Welcome to Quick Counsel with Kristen and Aaron, where we provide you with a practice tip or an overview of a legal issue in just a few minutes. My name is Aaron Van Kampen, and I am the research and training attorney for Wayne County's assigned counsel. I am going to talk to you today about body-worn camera footage. We're going to talk about why it matters, how to get it, and what to do if you can't. Body-worn camera footage is ubiquitous in cases these days. It exists in almost every single case, and it's critical to help you identify key witnesses that you may want to interview. It also can be a source of potential impeachment material, and it frequently can offer support for constitutional challenges to the admissibility of evidence based on the Fourth, Fifth, and Sixth Amendments. How do you get body-worn camera footage? Well, you're going to want to start early in the district court from the time you're assigned to the case. You're going to want to send a discovery demand to the prosecutor via email as soon as possible. You're also going to want to make a record of the fact that you've made these demands of the prosecution, and you're going to possibly also want to seek a court order compelling production. Then you're going to need to follow up. You may have to litigate motions to compel in order to get what you need. The key authorities you're going to rely on to do this are Michigan's discovery rule, which is MCR 6201. The subsections of this rule require the government to provide you with statements of any witnesses the government might call, police reports and interrogation records, and any statements of your client or your client's accomplices. You may also want to point out that under MCL 780.316, the police are required to retain body-worn camera footage for at least 30 days under any circumstance. And if there's an ongoing investigation or prosecution, they need to retain it through the duration of that case. It's really important when making your discovery request to be as specific as possible. For example, requesting any and all video footage recorded from body-worn camera devices by various officers listed in the police reports, right? Specify them by name, mention the date, perhaps an incident report number, etc. Also consider requesting some additional materials, including departmental policies related to recording, using, retaining body-worn camera footage. You may also want to request a couple of things that I'll talk about in more detail in just a moment: the device audit trail and the evidence audit trail, as well as the officer's activity logs. Consider requesting dash cam footage, and consider requesting the device manuals for the body-worn cameras used by the department. The device audit trail is a log of how a body-worn camera is used during an officer's shift. It keeps a record of when the device is turned on and off and the duration of recordings. This log is generated independent of the user, so it can help you determine if the officer has been manipulating their device or is lying or misrepresenting whether or not a device was being used at the time of the incident. The evidence audit trail is a log of when body-worn camera footage has been uploaded into evidence.com, and it will show you who uploaded that evidence. This can also be very helpful to show that evidence exists that's not yet been provided to you. And the evidence audit trail can also help you determine when something was uploaded, if it was uploaded improperly, and who was responsible for that. The officer's activity logs are different from the police reports. They exist for each shift an officer works, and they sometimes include information that is omitted from police reports or might contradict them, so they could be useful sources of impeachment material. With discovery, it is super important to follow up. That means you need to continue to pursue the discovery that you've not yet been provided in circuit court. You want to continue to document your efforts to obtain the discovery you've requested through email, and you may need to file motions to compel. You are going to want to make sure you have a clear record of what is missing, what the government is claiming is missing and does not exist. And then you may want to consider requesting an evidentiary hearing to further develop the record about why something no longer exists, if it did once, if it was destroyed, the circumstances, etc. And that's going to be really important if you decide to seek some sort of remedy or sanction for the discovery violation. The remedies available for a discovery violation are pretty broad. They are described in MCR 6201 subsection J. They include orders for production of discovery, adjournments, suppression of undisclosed evidence in violation of court orders, and any other order the court deems just. So what else might you ask for? Consider potentially asking the court to exclude the testimony of an officer involved in mishandling body-worn camera footage. Also consider asking for a special jury instruction that would allow the jury to make an adverse inference from the government destroying or failing to preserve body-worn camera footage. See Model Instruction 5.12 for an example of an instruction that could be modified this way. Potentially, you may also want to ask for dismissal. Keep in mind that dismissal is a remedy that our appellate courts are very hesitant to affirm when it comes to discovery violations. But there is some case law that supports the idea that dismissal is an appropriate sanction for a willful discovery violation. And that's the case of People versus Banks. If you're seeking dismissal, it's important to emphasize the egregiousness of the government's conduct that resulted in the violation and the prejudice to your client. Finally, depending on the circumstances of your case, you may want to also make a record of constitutional arguments that support dismissal or some other sanction, particularly under Brady versus Maryland, if there is some indication that the government has suppressed favorable evidence, and under Youngblood versus Arizona, if there is evidence that the government has destroyed evidence in bad faith. Both of those situations can be due process violations and further support your request for dismissal. This has been Quick Counsel with Kristen and Aaron. If you are interested in CLE eligible training videos and more, please check out our website at WayneCountyDefenderTraining.com or use the QR code on your screen.